This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on the dynamic trends shaping the legal world. Learn more at pli.edu/ftpod.
Welcome to Fast Tracked, Emergent Issues in the Legal Profession, brought to you by the Practicing Law Institute. I'm your host, Jen Leonard, founder of Creative Lawyers. Buckle up as we hit the gas and explore the most dynamic trends shaping the legal world, from generative AI to DE&I and everything in between. I hope you'll join us as we explore the future of law today. On today's episode, we're joined by Jordan Furlong, legal sector analyst and forecaster of the future of law, and Jim Sandman, distinguished lecturer and senior consultant to the Future of the Profession Initiative at Penn, Carey Law. Jordan and Jim are joining us today to talk about the future of regulatory reform and attorney licensure. I'm excited about this one. For today's episode, I really wanted to bring Jim and Jordan together to talk about two of the biggest structural challenges to innovation and driving real change in the legal profession, particularly around attacking the civil justice crisis. And those two structural issues are the regulations that govern the provision of legal services in the United States and the methodology and practices that we use to admit new lawyers to practice. And so welcome, Jim and Jordan. Thank you so much for being here. And I'm going to start with Jim, if that's okay, and just ask you, Jim, you have spent your entire career, especially the second part of your career, advocating as a reformer and as self-proclaimed radical around change to the civil justice system. And I know you've really focused your efforts on regulatory reform. And of all the different ways that we could make change in our profession to drive greater accessibility, why have you chosen to focus on regulation?
I start from the proposition that we have a highly dysfunctional market for legal services in the United States. It's a market that year after year proves itself incapable of generating a supply of legal assistance anywhere near sufficient to meet demand. The magnitude of the dysfunction is borne out by a number of indicators. I'll give you three quick ones. First, both parties have lawyers in only 24% of civil cases in state courts in the United States, where about 98% of litigation in the United States occurs. The image we have of what goes on in a courtroom, where lawyers for both sides present facts and argue the law, is a fiction in more than 3/4 of cases in the United States today because so many people can't afford lawyers. Second, the Legal Services Corporation did a study in 2022 that attempted to measure the magnitude of what they call the justice gap, the difference between the civil legal needs of low-income people and the resources available to meet those needs. The study found that 92% of the civil legal needs of low-income people get either no help at all or inadequate help. A third data point. There's an organization called the World Justice Project that every year ranks the countries of the world on their compliance with various indicators of the rule of law. They call it the Rule of Law Index. One of the factors they look at is the affordability and accessibility of civil justice. In their most recent report, issued just last October of 2023, the United States ranks 115th out of 146 countries for the affordability and accessibility of civil justice. And among the 46 wealthiest countries in the world, ranks 46th, dead last. This is happening in a highly regulated market. When you have a highly dysfunctional market that's also highly regulated, you might ask yourself whether the system of regulation itself isn't causing the dysfunction or at least contributing to it. And my answer is, it's causing it. And it's causing it in two ways. One, restrictions on the unauthorized practice of law constrict the supply of helpers available to people who have legal needs. Restrictions on unauthorized practice permit only licensed members of the bar to provide legal assistance. If you're not a licensed member of the bar, no matter how smart you are, how competent you are, how ethical you are, if you provide legal assistance to someone, you run the risk of criminal prosecution in most of our states. Second, the regulatory system prohibits fee sharing and investment by non-lawyers in legal services providers. That stifles innovation. There's no capital, not sufficient investment available to innovators to do something to try to address the dysfunction in the market. So I think that the regulatory system is actually, which is supposed to be preventing harm, is actually promoting harm by depriving people of access to the services they so desperately need and of deterring the innovation that our system requires.
Jim, the statistics that you've shared are so stunning and striking and certainly irrefutable from the argument that we don't have a problem. And we're talking about a profession that's so critical and analytical and focused on precision of data points. Do you think that raising awareness of these data points is sufficient to generate momentum around change? And if not, because I know you've spoken on this issue many times to many lawyers, why is there resistance to change or even an acknowledgement that we've created this crisis as a profession?
I think there is a significant knowledge gap about the magnitude of the problem. Most lawyers realize there's a problem for low-income people who are financially eligible for but can't get access to legal services because legal aid programs are inadequately funded. What they don't understand is that the problem runs well up the income scale. It affects not only low-income people who qualify for legal aid, it affects the middle class as well. The statistics I cited are unknown, I believe, to the vast majority of American lawyers. When I do have an opportunity to present them to a room full of lawyers, I can literally see jaws drop. Lawyers with commercial practices are never in the courtrooms where so many people don't have lawyers. It's just an aspect of the legal system that they don't have exposure to. So I think education is critically important. But I don't think it's sufficient because how long will it take to educate enough people to move the needle? I think the problem is more urgent than an education program could possibly be sufficient to address.
We're going to move on to admission in a minute, but I'd love to stay with that point for a second. I know you have spent many years teaching at Penn Carey Law. I've had the great privilege of working with you there. All three of us have worked with different law schools. I never heard about this when I was in law school, certainly. And I know when I've seen you speak with students, they're very stunned about the statistics as well. Why don't we share more about this from the very first days of legal education? And how could we do more of this?
I don't know. I think it should be a part of the required curriculum in every American law school. No law student should graduate from law school without knowing something about the statistics that I started out with. That's the state of the legal system they're going into, that they're going to be devoting their professional lives to. Don't you think they should know something about that? And they shouldn't be required to learn about it in elective courses only. This should be part of the mandatory curriculum. It's a critical reality of the legal system in the United States. Why wouldn't you educate every law student about it?
It's a great question and one I don't have an answer to, but I do want to think about the great people who are coming into our profession. And also, as you mentioned, Jim, the helpers who are competent and intelligent and could be supporting more legal services. And turn to Jordan, I know you've written a great deal and advised a great deal around trying to think differently about bar admissions criteria. What do you think the connection is between the statistics Jim just shared and the way that we admit people to practice, and how might changes influence access to legal services and also the quality of the access to those services?
Yeah, Jen, thanks for that. And the short answer is that, of course, there's a direct line, a connection, if not causal, between those two. The long answer, which I'm now going to give you, which is my typical, 7-minute answer to a 7-second question, so I apologize in advance to the listeners. But when we look at regulatory reform as part of this conversation, the statistics that Jim has noted and the problem that he has defined is significant. And there is no question in my mind that we need to do something very soon about the liberalization and the modernization of the supply side of the legal market. But I actually think it goes deeper and it goes broader than that. So I look at it this way: regulatory reform is, or at least it ought to be, about asking what goals are we trying to achieve through regulation, right? Are they the right goals? Are they the only goals that we should be trying to achieve? And are we employing the correct measures to achieve them? And I think we have to look briefly at each of these three questions. So, number one, like if you ask any legal regulator, and I know that we all have from time to time had these conversations, what is your objective as the regulator of legal services? And they will almost invariably say, we are here to protect the public in the delivery of legal services. To which I say, okay, great. That seems like a sensible goal to me. Legal services are important. They are credence goods. People don't know when they are buying these goods if they're going to actually accomplish what they need them to. They're complicated matters. There's a lot of bad actors out there looking to exploit people. Totally behind the idea of protecting the public in this regard. But is that the only goal? Right? Because if the only thing we're looking to do here is to protect the public interest, then we would place the highest possible standards of quality on lawyers. Right? Law school would be 10 years long. We would have the bar exam would have 90% failure rates. We would have 5 years required mandatory apprenticeship before you could come near a client. Right? We would do all these things. We would end up with 47 lawyers in the continental United States, but at least we would be assured they were the best 47 lawyers who've ever lived. So obviously that is not our situation, because another goal of regulation is to ensure that people can actually avail themselves of solutions to their legal problems. Right? So, and we will make some sacrifices in terms on the quality assurance side in order to expand supply. That is what regulation fundamentally is all about. Okay. I rarely, if ever, hear regulators talk about this goal, right? They talk about public protection, but not about public accessibility. And we can see the results of that, right? Lawyers are, as Jim has pointed out, they are in practical terms inaccessible to most people. So the very first step in any regulatory reform process, to my mind, is to make both of these goals, quality and accessibility, equally important to regulators. And if I ran the zoo on this, that would be my number one goal in terms of reform. Okay. But then we have to ask the next question, which is, okay, so even if we've got the right goals in mind, are we employing the right measures to achieve them? And to my mind, the answer is like, no, not remotely. So, for example, and this is on my little soapboxes, I'm going to clamber up on it and go forth in this. The law degree. The law degree is a mandatory requirement for licensure basically everywhere in all practical terms. In the United States, law school is sufficiently expensive that the average graduate comes out $148,000 in debt. That does a number of things. It creates massive barriers to entry at the starting point. Many people simply don't apply to law school. They know they can't afford it. They know they have no shot at it. This is particularly disadvantageous to people from certain socioeconomic backgrounds, to people with certain racial backgrounds, and we end up with not only a more limited supply of lawyers, but also a less diverse and representative one. Okay. But we also, of course, have massive costs at the other end. People come out of the legal education licensing process deeply in debt. They have to drive up their fees and their salaries in order to help pay this down. It limits their options in terms of to whom and where and how they can offer legal services. So law school, in this regard, is going to obviously have an impact on the accessibility of legal services. But here's my thing. I think it also fails to meet the goal of public protection, right? I mean, I suppose it meets the goal insofar as someone with a law degree is better positioned to help you as a lawyer than someone with nothing, I guess. But the law degree itself, as we know, is painfully inadequate as an element of lawyer competence, right? And this is not something that serious people argue about anymore. This is widely accepted within the profession, and I think even secretly within the academy. The law degree does not, as we know, even prepare you to write the uniform bar examination. You have to go and do more study, and you have to hire a company and pay them a lot of money to prepare you in all these regards. So when a lawyer does enter practice, they find that they do not have the knowledge or the skills to be competent lawyers. And in fact, they must find out they actually have to unlearn so much of what they've already gone through. They have to unlearn all these habits and process and activities. And I hear this all the time from law firms and professional development directors and recruiters to say, we have to break them of all these habits they've spent 3 years and hundreds of thousands of dollars acquiring. So that's just one example. It's a big one as far as I'm concerned, but it comes back to this question of what goals are you trying to achieve and are you going about it the right way? So my point, and I am finally coming to it, is this. Regulatory reform involves us asking two questions. Number one, are we trying to achieve the correct goals, plural? And two, are we going about it the right way, trying to achieve these goals? My view on it is that if we ask and answer these questions correctly, bar admissions will take care of itself. It will solve itself because bar admissions is a natural outgrowth of the bar admissions crisis, fiasco we have in your country and in mine, because I'm here in Canada, is a direct outgrowth of the fact that legal regulators are setting, I think, the wrong or incomplete goals for themselves and are going about achieving those goals the wrong way.
Thank you both so much. That was such a comprehensive stage setting of the challenges that we face and our misaligned goals. And I'm going to ask this question because I genuinely don't know the answer to it, and I think that I should. I know that lawyers are regulated by the states in which they practice, by the Supreme Courts and their affiliated organizations that support their efforts on regulation. How frequently do the state Supreme Courts revisit the goals of the regulations they've created in a real comprehensive way and think about the questions that you've just asked, Jordan?
I cannot speak directly to the state Supreme Courts. I cannot remember the last time a state bar did. I suppose the last time probably was when the State Bar of California was hived off from what is now the California Lawyers Association. It took on an entirely regulatory role. Then they retained an extraordinarily great document from Professor Bill Henderson that looked at all of the issues that Jim has identified here today and said, this is how you rework your regulatory system in order to achieve that. So I think that was in practical terms a revisiting, not that it has helped the State Bar of California to achieve that for other reasons we can talk about a little bit later on if you like. And I can tell you that here in Canada, the law societies, which are the regulators, the courts have no role in regulation in Canada. It's the regulatory bodies, which are creatures of statute fundamentally. There's an awareness of, and you will find oftentimes in the more recent amendments to enabling legislation, you'll find not just protection of the public, but also improving access to justice. The challenge, however, is that when you are, as a regulator, trained to think about public protection, if you're going to protect the public, the way you protect them is you don't let anything happen to them, right? Remember Finding Nemo when Marlin at the end is, saying like, I can't let anything happen to him. And Dory says, well, then that's a pretty miserable life for him, isn't it? Right? Nothing's ever going to happen to him. So what ends up happening is that you're saying to regulators, protect the public, but increase access to justice, which for them is like, okay, I'm holding the door closed with one arm and I'm pulling it open with the other. And it just doesn't fly. So we need to be very explicit about the mandates that we want them to achieve, and we have to help them understand it is a balancing act, and it's not about being exhaustive, and it's not about being in full control of the market. I'll talk about that a little bit later on. It is about trying to understand what your goals are and what the best way to achieve them might be.
I can't think of a single state Supreme Court that in recent years has gone back to ask the fundamental questions that Jordan posed, starting with the question, why are we regulating? What is the purpose of the regulatory system? That should be question number one. I think there are states that have asked the question, how should we regulate? But without first asking, why are we regulating? And to me, the first answer to that question is we should be regulating to ensure that every person, regardless of their educational level or their income, is able to participate meaningfully in the legal system that was created to serve them. And only after I've answered that question would I get to the question about protecting the public. But I can't think of a single state that's gone through that kind of analysis. We have the lawyer's tendency to sort of accept the status quo, the precedent, and try to tweak it rather than going back to first principles. The state of affairs today is such that we need to go back to first principles and ask the most very basic of questions.
And Jim, I just want to throw one other thought there, which is that we talk to, again, you talk to regulators and they say, we want to protect the public. And I say, what are you protecting them from? What precisely is the thing from which you were trying to protect them? And this is why you're absolutely right. The access question, the availability question has to come first, because there's got to be something out there for them to be able to access. Once it's there, we can talk about how best do we protect them, or what I would prefer we phrase that, how do we protect their interests? How do we help advance their interests? Because protecting someone's interests is not the same thing as protecting them. Protecting is shielding. Protecting is treating them like a child, going back to Finding Nemo, right? And I don't think we should be treating people as children in the regulatory context. I think we should be understanding that they're adults. They are as sensible as any of us are at any given day of the week. And what they need is help in advancing and protecting their interests. And it's up to them to decide what those interests are, not those of us on the supply side of the ledger.
Well, I'm really grateful to you, Jordan, for invoking Finding Nemo, because it shakes off the terror of your earlier suggestion of 10 years of law school. So it's a nice, and I really wanted to explore the state Supreme Court's role here. I started my career in our state Supreme Court, even as the liaison to the disciplinary docket. And even as somebody who worked closely with the regulation function, I didn't think of the Supreme Court's primary or even main job as regulation. And we're at this moment where you've just outlined the lack of reflection and intentionality maybe with the way that we craft regulations. And now we have transformative technologies that are emerging and accelerating all around us. And I've been really curious since generative technologies hit the scene, how state Supreme Courts will grapple with this, their level of awareness of the floodgates, I think, that are about to be opened. And to Jordan's point, there really could be a moment of real need to protect the public from some things that could be leveraged to harm them. But there's also huge opportunities, I think, to scale some of the solutions that people have been building in the background with less powerful technology. So, Jim, I want to come back to you and ask how you think these emerging technologies could reshape the way that we govern the practice of law in the future, and how messy will it be in the short term as these technologies and their uses start to collide with an antiquated regulatory system?
I agree with you about perceptions of the role of state courts and people not thinking of them as regulators of the legal marketplace. But they are. They are the regulators of the market for legal services in the United States. Most lawyers, most members of the public, I'd hazard a guess, most state Supreme Court justices themselves think of themselves principally as deciders of cases, and sometimes as only that. But I think that the emergence of generative AI and other technology tools really focuses the need for state Supreme Courts to recognize that much broader role that they have. I think emerging technologies, particularly generative artificial intelligence, offer the potential to democratize law. Part of the problem with our system today is a lack of access to the information that people need to recognize their rights and to assert them. And technology is great at spreading information at scale. Now, of course, there are risks. Is the information accurate? Is it reliable? Is it understandable? But I think that generative AI offers the potential to make accurate, understandable, usable assistance available to everyday people when they need it for the problem they have. Think of that. What an incredible thing. And don't we want to enable that in a responsible way rather than try to shut it down from the outset? But I think currently we have limitations on the ability of that technology to realize its potential. Two of them are restrictions on the unauthorized practice of law. Somebody's going to make the argument that generative AI is practicing law, that it is offering not just legal information, but legal advice and assistance tailored to a particular legal need, which meets the definition of the practice of law and therefore can only be provided by a licensed lawyer, a human being. I also think that making this technology available at scale to the people who most need it requires creative investment and innovation in a manner that is severely limited by Rule 5.4 of the Rules of Professional Conduct, which prohibits fee sharing and non-lawyer investment in legal services operations. So I think that we're looking at the potential for technology really to transform the legal system, but we're also looking at significant barriers to doing that are imposed by the regulatory system as it currently exists.
Jim, I just want to build on briefly on one point you made there, which I think is really important, talking about the idea of investing people with knowledge and awareness of the law and what their remedies are and their options are and their rights are as people under the law. And this is something that when we talk about access to justice and so forth, it's a subject that I kind of come back and hammer on fairly frequently. I said, look, everything we're doing to not just expand the supply of legal services providers, but to make them more affordable is a very good thing in and of itself. The supply side is where 99% of the A2J work has been done up to this point. But I really wish we would spend more time on the demand side. I wish we would help not just to lower the ceiling of accessibility, but to raise the floor. Put people in a position where they have more, not just more knowledge and more awareness, but they have access to these tools. And maybe they're generative AI. Maybe it's just standard automation. Maybe it's something that we haven't invented yet, but it's a tool or a process or an institution or a procedure by which people can not just learn what their rights are and what their remedies might be, but actually begin to access it. Walk some distance down the road toward their own goal, whatever their own goal might happen to be, before they have to or feel the need to engage the services of a professional or some kind of a helping institution. So the more we can do to raise that floor, the better we're going to be. And I'm not talking here about the legal profession, I'm talking about society, in order to be able to actually achieve that goal of widespread justice accessibility.
And one other item I might add to your list, Jim, of reasons why generative technology might not really have the effects that we want it to because of the regulations is what you referenced earlier, which is the accessibility of the legal information in the first place. It seems that we have the benefit as a profession of really trustworthy underlying data, which other fields don't have necessarily as organized as we do. But of course, it's locked away from the public and they don't have the ability to use it. Do you see that as a problem that will perpetuate the ability of corporate clients to get access to these powerful technologies at the cost of the regular person or small business not having the benefit of these new ways of accessing help?
I do. I think that access to important legal information that people need to be able to recognize and assert their rights is currently proprietary and available only for a fee to people who can afford to pay for it. I think that generative technologies actually present a potential risk of widening the justice gap by making cool new tools available to rich clients and their lawyers that will not be available to everyday people who don't have lawyers. That will make the problem worse. So the problem that you're identifying is one of longstanding, the accessibility of things like case law only for a fee. And why is that? The people own the legal system. And if they can't use it without access to information that's currently proprietary, it's just failing them. That's a basic problem we need to solve.
Yeah. And you and I have taught classes together where we emphasize the importance of curiosity about why things are the way that they are. And that seems like such a weird thing if you spend more than a second thinking about it, especially given all the restrictions we put up around being able to access somebody to help you figure it out in the first place. Another weird thing I've been thinking about recently on the private sector side is this idea that our graduates who enter law firms don't ever see a job description for the job that they're going to do. They just go to on-campus interviewing and interview for something that they assume will be taught to them when they get to their place of employment, which brings me back to bar admissions and also the weirdness of the profession in the way that we do things. And Jordan, I know you've thought for a very long time about how we might emphasize different skills and different ways of assessing and making sure people have those skills to enter practice. So I'm curious how you think the lawyer admissions criteria should change, and maybe how we should stop hiding the ball from new lawyers about what the job is that they're actually going to be doing, or at least not making it as confusing as we do at the entry point.
That's a great point, Jen. You're absolutely right. I mean, people show up the first day of working in a law firm, and they don't have any sense of expectation of what's ahead. Almost all of their beliefs and expectations around what's coming is what they've heard in law school or what they've read about at Above the Law, and most of it is completely misleading and inaccurate. And it's pretty astounding that law firms do such a poor job of preparing their future workers for their first day on the job. But if we were making a list of things law firms did poorly, we would have an entire different podcast to occupy ourselves with. When we get to the question of skills at the entry level, my starting point on this is that a nice start here would be to actually require some skills from people when they are first licensed to become a lawyer. Now, in fairness, and I try not to bend over backwards to be fair to the legal education, but in fairness, you do pick up important skills in the legal education process. You learn or you improve your critical thinking. You get really good at marshaling a legal argument. You understand how to interpret a contract or a statute, right? These are actual skills. This is knowing how to do something. So that's great. And there are, of course, myriad skills well beyond that. We've been talking about in the practice management field for at least 20 to 30 years now. Now, here's the NCBE, and they say that the new bar exam, which will come in, I don't know, sometime at the end of this decade or near the end of the decade, will include a wide range of skills that are not currently tested. Okay, great. But there's three things here. The first is you don't learn a skill by reading about it and answering questions about it in an essay format or a multiple choice format, right? Or at least you don't learn it just by doing that. You learn a skill by doing it, and you do it repeatedly. And you do it getting constructive feedback from an engaged supervisor who is qualified to give you instructions, encouragement, and to help develop you going forward. Now, until we are in a position and we are ready to institute reforms to the licensing process that make these elements part of the licensure process, then we are really only pretending to really do anything about skills on the legal side. Okay. Now, the corollary of that, and that's my second point, is that instituting these kinds of reforms would be an enormously complicated and expensive undertaking. Right? We would need, where do you start? You start by creating an extensive and sophisticated competence profile describing the knowledge and the skills and the experience and the professional awareness, responsibility, and development that you are required to have as a competent first day lawyer, again, before we will let you loose on a client. And then once you've figured what all that is, then you need to build systems to teach all that, because that is very obviously not law school. And then, and this is actually the really hard part, you have to build systems to assess all of it. And the assessment is really tough. And I'll just put that into context. We are just now, here in Canada, we are just now starting down this road in earnest. There is a group called the Western Canada Competence Task Force. It is constituted by four of the law societies of the four westernmost provinces. And they are working on, and I'll grab my horn and give a little here to say they're working on some recommendations that I made in a report to the British Columbia Law Society a couple of years back. They are well on their way to establishing this competence framework for entry point lawyers, which is fantastic. It is a massive step forward for licensure reform. In addition to that, when we talk about the assessment piece, we have two bar admissions programs here in Canada. One is called the Practice Readiness Education Program. That is an operation in 4 provinces. Another one is called the Law Practice Program, which is an alternate option here in Ontario, where I live. And that these include not just the inculcation of skills and the practice of skills, but the assessment of skills at the end of the process, which is fantastic. And I keep raising this with my friends in the United States to say, this is not impossible, what I'm describing. It is something, we're doing it right now. I'm not saying we're doing it fabulously. I'm not saying we're doing a great job of it, but we're doing it and we're figuring out as we go along. So yes, we still have a very long way to go. But my worry about the US is that you're nowhere near that process. And then finally, it comes to the third point. And the irony is, for me, and it's not a good irony, is that just as we are now seeing some real progress towards licensure reform and assembling a competence framework and finally deciding that we're going to define and enforce what it means to be a competent entry point lawyer, to your point, Jen, here comes generative AI, and it's just blowing everything up, right? And now, and I will say, and like I make this my study, I make this one of my specialties, and I could not tell you for the life of me what in the year 2030 will be expected of the in terms of competence and preparedness for a new lawyer entering the profession at that time. I just don't know, right? Because generative AI has such a wide range of possible outcomes, it's impossible. I mean, you can throw a dart at the board and get a decently sourced guess at it, but that's really all you've got. So the way I described it the other day was, it's like, we finally just about gotten to the summit of Mount Everest, and we get there, and someone stuck another Mount Everest on top of it. And now we have to go through this process again. So it's we have our work cut out for us, right? None of this has ever been easy, but it's just gotten so much more complicated lately. Oh my gosh.
Well, and it doesn't seem like that's going to change, right? And I remember being in professional development work 8 or 9 years ago and hearing about the next gen bar exam, and it's not even here yet. And it was so exciting and so much, generation of energy around it. And now, like you said, the whole world is different. So by the time it gets here, you already need something new, and it's such a deliberative process, and it takes so many years that we know how that story will end, because there'll be something different to combine with generative AI. So maybe, Jim, this is maybe a curveball question, but we have law schools that charge students a lot of money to learn to prepare for the profession. And then we have employers who don't provide a job description because there's so much trust that they will teach them what to do when they get there. What is the value of this intersecting piece between the two of them? And how can it become more nimble if we think there is real value in making sure that there are the skills present to enter those jobs?
I don't have a great answer to that question. I'm trying to think of the mechanism to get there. What players you would need to bring together to make that happen? What is the body that could implement what it is that we're talking about? The regulators, the accreditor, they don't have the ability to corral law firms in the way they do business or train their people. I think there really needs to be a profession-wide recognition of the need to rethink how we train lawyers before you can get to the implementation stage. And I don't think we're there. I think too many law firms and too many individual lawyers think, hey, this worked pretty well for me. I got hired. The system must be working well. I mean, ultimately, I think there are 2 points of regulation that have the potential to make a difference. One is the accrediting authority. The American Bar Association's accreditation function for accrediting American law schools is an opportunity to impose requirements on law schools. The other is admission to the bar. Everybody's got to go through that process, and there's another opportunity for a body to intervene and say our standards are going to be different. The two need to come together. Now, I think it is interesting that the body of the ABA that regulates, I think it's the Council on Legal Education and Admission to the Bar. That title is interesting. They recognize in that title the need to coordinate the two. But I'm not sure how much that happens in practice now that I've said it. So I think it needs to be more than just the title of a council in the ABA. It's something that needs to happen really on the ground in a much more interactive way than it currently does.
Jim, that's such an important point. And I will say, again, we're really fortunate here in Canada because our accreditation authority for law school and our admissions authority and our regulatory authority are all basically the same organizations, which again are these law societies. And a brief sidebar on accreditation, there's an umbrella group here in Canada called the Federation of Law Societies of Canada. And they have a bunch of responsibilities. And one of them is figuring out what are the required competencies that law schools are supposed to be able to inculcate and to teach in order for them to be considered, we'll recognize a degree from your school. And just very recently, the Federation has issued a new updated version of those requirements. So I I recommend it to American friends in this area for reading interest. But the point I kind of wanted to make on this whole area, Jen, you asked about how can we go about creating a better approach and a better system, and for everything we've described here, obviously it's a pretty challenging task. But I do think it is achievable, and I think that as an operating principle, and I would love to see this become built into our systems, both in Canada, the US, and elsewhere. I want to see this become a more user-centered process, right? The bar admission process right now is something that is done to people, right? You are tested and you are forced to do this and you have to do this and so forth. And at all times, and you're being challenged at all times. And that's a funny thing, right? There is so much that is unwelcoming about the lawyer licensing process. This entire process, from the day law schools set their tuition to everything that goes forward, this is a profession that puts out a big sign saying, we don't really want you here. We want, if I can paraphrase or rephrase PJ O'Rourke, he used to use this term and talk about overpopulation. Just enough of me, way too many of you, right? And that is the way that legal regulation tends to go about this. So I want to see a user-centered process. I want to see a user-friendly, literally in the sense of, we're happy that you're becoming lawyers. We're happy you're here. We're delighted. That's awesome. Come on in. We're going to be obviously very precise and challenging to make sure that, yes, you are competent and you are confident and ready to do all these things. But fundamentally, we'd rather that you are here rather than not. And that is absolutely not what this system currently says.
I like Jordan's description of the Canadian process, or should I say the Canadian process, where the regulatory functions, accreditation, legal education, admission to the bar, disciplinary authority, are all exercised by a single body. We've got that trifurcated right now. And even though, as I said, the ABA has a council on legal education and admission to the bar, they have absolutely no authority over admission to the bar. Their role is purely consultative. They do have authority over accreditation of law schools. Even though admission to the bar and the disciplinary function are under the authority of state Supreme Courts, they're usually bifurcated. They're handled by two different committees, two different functions. That I think there's great wisdom in the system that Jordan has described.
And just to sort of tie back to the message that we give to new people in the profession, Jordan, the one thing I was thinking as we were describing all of the things that you need to do to become a lawyer, from the LSAT all the way through the bar exam to the interviewing and apprenticeship, and then we lose everybody. So it's like we just bear down on people for so long, and then it doesn't last that they're with us anyway. And I also wrote down earlier, the language that we use to talk to people. You get to law school and it's, we're going to break down and destroy the way you used to think and build up something better. And then you graduate and go to an employer and it's, we're going to break down the way they taught you to think in law school and build up something better. It's just such an abrasive and oppressive tone to set for people that really want to contribute and solve problems for their clients.
I have often described, toxic masculinity as a professional culture kind of being the hallmark of the law in so many ways. So yeah, I think that operates. Yeah.
Yeah. And so much of what you're talking about, I mean, these are huge structural problems with lots of interests and stakeholders and all of those things. But so much of it also is about mindset. And, I didn't think about it, frankly, until Jim and I started working together about the idea of the privilege of self-regulation. Because even though we are self-regulated, to both of your points, I never really felt in control of the regulation. I felt afraid that I was going to deviate from the rules and get in trouble by the regulators. And maybe the mindset shift really is the human-centric piece of, if we have this privilege and we introduce this knowledge at the outset of your experience and we make it a more welcoming message to people to come help us solve these problems, that might start to shift the way that we think about the future. And Jim and I have talked with colleagues who work in the design school about just what you mentioned, Jordan, which is, I think there should be more design experts involved in the crafting of a bar admissions experience. What is it like to be a client? How do you engage with them? What are the purposes of the representation in the first place? And then work toward a solution. So many mindset shifts and the diminishment of the toxic masculinity. I like that. So I want to ask another question about legal education, because this is something where I was so biased for so long and my eyes were opened recently. I went to a conference in the fall with our good friends, Zach Zarnow and Danielle Hirsch from the National Center for State Courts, about rural legal deserts. And I live in Philadelphia, which is about as far from a legal desert as you can get. And it hadn't really occurred to me, the idea that people can't access legal education. One of the speakers told this very compelling story. He was from Indiana, about a mayor of a small town in southwestern Indiana who wanted to become that town's city solicitor because they didn't have a full-time solicitor. And he used to drive 2 hours each way every day to get a JD so that he could be solicitor for his town. And it seems like we had this pivotal moment a few years ago where we all learned to be online and do things virtually. But now we're bouncing back to this idea that everything needs to be focused on being in one place at one time. And Jim, I think about you. You take Amtrak up every week to meet with your students, and they're so lucky to have you to do that. But you could be reaching many more students virtually and expanding access to legal services. So what do you both think about the future of legal education? Jim, I'm going to start with you. Whether it really should be a place-based endeavor that has real value for the geographic proximity to people and learning and professors, or whether we should move to something more like an executive ed cohort-based model where you're together sometime, virtual sometime. What do you think?
I think we should do both. I don't think it's either or. I do think that making legal education more accessible may well make lawyers more accessible. You shouldn't have to move to go to law school. The example you gave of the person who wanted to be a city solicitor and had to go to law school to do it is to travel 2 hours each way to get to law school. That's a deal breaker for many people, particularly people who are already working, who aren't in the conventional law school track. Making law school more accessible to people, regardless of where they're located, I think would be a great. I checked this morning and I found that only roughly half or less of American law schools have some kind of part-time program or night school, which just accentuates the need to have something that's not geography-based at all, something that's available as people can do it. And I think that the ABA Council on Legal Education is moving in that direction to be much more generous in making accreditation available to purely, entirely online programs. I just think it, in light of the problems that we face, the magnitude of the problems we face, the number of lawyer deserts we have in the United States, why not? I know the problems that people can identify with remote education as opposed to in-person. I get that. But do you think the system we have today is working well? I don't know of a single study that says the American legal system is working well to serve individual people. It's time for us to think differently.
So one of my thoughts that coming out of your observation, Jen, is I go back to something Richard Susskind once said, which he used to talk about in the future. Court is not going to be a place, it's going to be a process. There again with Canadian pronunciation. And I think for a period of time there during the pandemic, and I think to a lesser extent probably going forward, that has actually proved to be the case. You don't need to be in a physical location to access the court. And once you've had that experience, you realize, of course you don't need it. In fact, that may actually not be all that helpful. The same thing operates completely for the idea of legal education. And, it does not have to be at a particular place. Again, we had that experience during the pandemic. Now, I don't think anybody who went through law school and spent 2 of their years remote learning would have preferred that over the system that we had. I don't think that an entirely remote process or an entirely isolated process, more to the point, is in anyone's best interest. But I think if it broke us of the habit of saying you must all be in physical proximity with one another, then I think that's a good first step. And related to that, I mean, you mentioned legal deserts at the start, and I've seen all of those studies. And again, and I think, Jim, the term you used is actually, I think, more appropriate. They're lawyer deserts. There are places where there are very few lawyers. I was driving through a part of Saskatchewan the other day where I think if you drove an hour in any direction, 2 hours in any direction, you would not sniff a lawyer, right? But a lawyer desert doesn't have to be the same thing as a legal desert, as a legal solutions desert, as a legal options desert, if you have access to the internet. And I know there's many parts of both of our countries that don't, but at least most people are a whole lot closer to Wi-Fi than they are to a lawyer, and it's a whole lot more affordable. So, right, if we get past this idea of focusing on the institution, focusing on the provider, this goes back to my point about user-centered. I think the lawyer licensing process should be focused on the licensee. I think the delivery of legal services should be focused on the person who needs the dang service. So to answer your question, how do we make law school and legal education more accessible? The easiest, and again, when I say easiest, sorry, I should say the simplest, which is my current mission. And if I can help achieve this by the time I'm finished yapping away as this profession, I'll be a happy guy. Make it optional. You want to make legal education accessible? Make it optional. Remove the requirement that you must have a 3-year law degree in order to start the bar admission process. And I think that would open up vistas that we have not even begun to consider yet, and would have massive benefits. But again, it's this idea of, let's lose this idea that we have inherited, that there are all these fixed points of necessity in the process of becoming a lawyer that we cannot do without and we cannot fundamentally change. I don't think any of that is true. I think we can change whatever we feel like fundamentally. So that's the approach I would prefer to see us take.
Well, that is a provocative proposal, and I really interested to follow your journey in advocating and achieving that, Jordan. And thank you both for your thoughts. And I would just say, as a teacher during COVID, I definitely see the value too of in-person. There's nothing like being in a classroom for students. So I think there's some way to learn from what we experienced and make online components available and valuable that are supplemented and complemented by the in-person piece. And so I could talk to both of you all day. I feel really privileged and lucky to have spent this time with you. And I just want to finish off our conversation with optimism, which is where I always like to land, and I'll start with you, Jordan. What's your biggest hope right now from where we sit with all the change swirling around us for the future of legal service delivery?
I think that my biggest hope, Jen, lies in the fact that precisely what you've just said, in the forces of change that are swirling around us. They are far above our pay grade. They are well beyond our ability to control as a profession. And to be quite honest with you, I think it is this need for control that we have as lawyers and that we have instituted throughout our profession and throughout our institutions that has caused us so much grief. Regulators like to control things. You talk to anybody who is involved in regulation of legal services, and they really dislike uncertainty and they hate chaos. And it's like, oh, it's so crazy. We have to bring this under control. It's like, you know what? Control is relative, and the power to control is unevenly distributed. And right now, other entities beyond yourself have the power to control, have the power to influence and change things. The legal system, the legal sector is going to change radically, to my mind, over the next 20 years. There is no question in my mind that's going to happen. How it happens, we can have discussions all day long. That will happen, I think, to me, feels undeniable. How painful that's going to be, a lot of it's going to come down to how painful are we going to make it as lawyers. If we insist on saying, we are the gatekeepers, we're in control, we know better than the rest of you, we're here to protect you and tell you what you can and can't have. If we insist on making that our mantra, then it is going to hurt like hell. And it's going to be bad for us, it's going to be bad for everybody else. I think it is absolutely time for us to recognize that change is upon us, and it makes a whole lot more sense to swim with this tide, swim with this current. We will get farther. We will go farther. We will do more and achieve more. I want to see us drop our barriers. I want to see us drop our resentments and our protectionism and just say what is in the best interests of the people we are here to serve. I was talking to a law school class just yesterday and ended off by saying, you are going to be lawyers, and a lawyer's job is to make things better. And if that is our mantra as a profession, we will have no difficulty whatsoever navigating. These are rough currents. These are challenging times coming up. But if that is our mantra and our North Star, we're going to be just fine. And so is everybody else.
Thank you so much, Jordan. And to close us off, Jim, what makes you optimistic about this moment we're experiencing and what it could mean for the future?
I actually have a process suggestion.
A process
suggestion, yes. Thank you, Jordan. My greatest hope for the future of legal services lies in a potential but doable change in the way we regulate, namely more public involvement in the regulatory process. We currently have a system where the regulated are the regulators. That is not a good system. If the purpose of the regulatory system is to serve the public, we have virtually no opportunity for the public voice, the people served by the legal system, to participate meaningfully in the regulatory process. The reason I'm optimistic is because there are some examples of public involvement in the regulatory process that have been shown in recent years to make a real difference. The best example is Arizona. If you want to see creative regulation in the legal profession, look to Arizona. They do things really well there. They have public representation on their regulatory body that's meaningful, not token, where the public voices aren't drowned out by the lawyer voices, where they have sufficient numbers of people who feel free to participate, to make their voices heard. And that model is being picked up in other states. I'll give a concrete example. Arizona is one of the states that's created a licensed paraprofessional program to surge the supply of helpers available to people who have legal needs so that more help than just licensed lawyers is available. And in that process, they sought significant public input through town hall meetings, a public survey, focus groups. They were very aggressive in reaching out to the public to say, you tell us what you think. And that public voice was a counter to the conservative lawyer voices complaining about the need to protect the public. The public was saying, please, we want this. Don't stop us from getting it in the name of protecting us. And other states, like Oregon, looked to that Arizona model and said they're on to something. And they, with help from the people in Arizona, they implemented a program for getting public input into their proposal to license paraprofessionals in the state of Oregon. And I know from my own work that's beginning to spread, the notion that you need to have the public voice heard in significant regulatory issues affecting the availability of legal services. It's a means to an end, but if you can significantly increase public participation in the process, you'll be on the fast track to getting the system where it needs to be.
Well, thank you both. And just to combine what you both said and sum it up in a nice, tidy phrase, I would say the future is about making things better by designing with the people that we serve our regulatory structure.
Absolutely.
This was such a great conversation. We covered so much ground, including Pixar references. And Jim delivered on what I always hope he will, which is having an enumerated list of 3 things, which I told him ever since I had kids, I can no longer attempt to do because I'll have a Rick Perry moment and fall off a cliff. So I'm always in huge admiration of your ability to do that, Jim. I want to thank you both for spending your very precious time with our audience today. I know that everybody learned a great deal and you offered some provocative thoughts for the profession to think about as it regulates itself in the future. And the theme, as it is on so many of our episodes here, is about the humans of law. So I want to thank these 2 fine humans, as well as all the fine humans listening to our episode today. We thank you for joining us, and we look forward to you joining us for future conversations on Fast Tracked. Have a great day.
Thank you for joining us on Fast Tracked. I hope you enjoyed this fascinating conversation as much as I did. Visit pli.edu for more insights, education, and resources for navigating this dynamic landscape. And until next time, stay curious and stay adaptable as we work together to chart a course into an exciting future.